Fagan, that's not how it works. I mean, the fact that it might map on to another theory of fraud isn't sufficient in a criminal case, because doesn't the jury have to be actually instructed concerning the other theory? What worries me is the thought that the jury was instructed, and Justice Sotomayor just read the instruction. The jury was instructed on this right to control theory, and they convicted on that theory. If we determine that that theory is not consistent with the law in some way, I don't know that we can look at the evidence that was presented, especially given the fact that, as Mr. Dreeben says, the evidence was presented tailored to that theory. But even so, you seem to be suggesting that we can go back now and look at the evidence that was presented and say, oh, but there was enough for another theory that the jury wasn't instructed on, and so we can sustain the conviction on that basis.
Well, 2 points, Your Honor. One, as the case comes to this court, and without prejudice to whether they may have preserved the other challenges below, as the case comes to this court, it's just a pure sufficiency of the evidence challenge. And what that looks at is, here are the elements of the statute properly construed, and here are the facts of the case, and do they map on to each other?
Wait, how can you say that when they have charged throughout that the actual law that was being instructed was invalid?
So if what the court wants to say is that the jury instructions were in fact invalid, I think they forfeited a challenge like that at right at the beginning of their petition cert stage reply brief. But again, the court could send this case back to the Second Circuit to sort out where we are now. But our submission in this court, and the reason we think this court can affirm, is that if the jury instructions could be characterized as essentially just misdescribing the elements of the crime, but in a way that wouldn't have allowed for the jury to find guilt without finding the properly understood from first principles elements of the crime, I don't think that the defendant has been deprived of anything. They point to evidence they would have introduced, but if you look at page 1002 of the Court of Appeals appendix, the district court judge made clear, I'm sorry, Your Honor.
Finish.
The district court made clear that it was open to evidence that Simonelli actually could have done this better than anybody else. What it wasn't open to was evidence that Simonelli just gave it a quid pro quo, which is exactly the kind of thing that we don't think fits even under traditional property concepts. Thank you, Mr. Chief Justice.